Ma'am, you need to leave this property.
Excuse me, I live here?
The homeowner reported someone's trespassing.
I am the homeowner. This is my house.
The caller said the owner is an elderly white woman. You don't exactly fit that description, do you?
The caller is wrong. I'm Dr. Simone Hartley. I've lived here 12 years.
It began with a sentence that sounded routine, a statement delivered with confidence, a claim of authority made without hesitation. The officer said she did not belong there, that the property was not hers, that she was trespassing. Nothing about the moment appeared volatile. No raised voices, no visible threat. Just a professional woman standing at a private residence she owned, being told calmly that she was violating the law. The officer spoke as if the outcome were already settled. It wasn't, but the system had started recording. Within months, that single assertion would trigger internal reviews, sealed filings, and a civil verdict measured in millions. A badge would be surrendered, a career would not recover, and the city would learn that authority, once exercised outside the law, does not fade quietly. The mistake had already been made. What remained was determining the cost. The encounter unfolded without urgency. The officer stood squared to the entrance, posture firm, voice measured, projecting certainty rather than aggression. There was no warrant in hand, no emergency call, no report of a crime in progress, yet authority was asserted as fact, not question. The doctor did not argue at first. She listened. She clarified that this was a private residence, that she lived there, that the property was hers. Each statement was met with indifference, as though ownership itself were irrelevant once the badge had spoken. The officer repeated the claim, trespassing, not as an accusation, as a conclusion. In that moment, the balance of power tilted decisively, not because the law supported the assertion, but because enforcement had already assumed it did. Procedure replaced verification. Control replaced inquiry. What should have ended with a simple confirmation instead hardened into a position that could no longer retreat without consequence. This was not a chaotic confrontation. It was orderly, controlled, precisely the kind of interaction that appears defensible until examined frame by frame. And that is what would come later when statements were transcribed, timelines reconstructed, and authority measured against statute rather than confidence. The outcome was already forming. Every decision after this point would only narrow the path back. Before the encounter ever became a legal matter, the woman at the center of it lived an unremarkable life by design. She was a practicing physician, known within her community for reliability rather than notoriety. Her days followed routine schedules shaped by patient appointments, hospital rounds, and the quiet administrative burden that comes with modern medical practice. Nothing about her public record suggested volatility, confrontation, or disregard for authority. She owned the residence outright. The property had been her primary home for years, purchased through conventional financing, registered in her name, and maintained without dispute. Neighbors recognized her. Local records reflected her occupancy. There were no pending complaints, no civil disputes, no history of police calls tied to the address. By every objective measure, she was exactly who she appeared to be, a homeowner returning to her private residence. Professionally, she operated under a license that required strict compliance with state and federal regulations. Her career depended on procedural discipline, documentation, and accountability. Deviations carried consequences far more severe than embarrassment. That background shaped her behavior in moments of uncertainty. She spoke carefully. She avoided escalation. She expected verification to resolve confusion. Socially, her standing carried an implicit assumption of lawfulness. Physicians occupy a space of public trust not because of status, but because of demonstrated adherence to systems larger than themselves. Years of training reinforced deference to rules, not resistance against them. When confronted by authority, her instinct was cooperation, not defiance. That context mattered, not for sympathy, but for clarity. This was not an individual attempting to exploit ambiguity. She did not challenge jurisdiction. She did not invoke legal jargon. She made a simple factual assertion that the property was hers and that she was entitled to be there. At this stage, the encounter still possessed multiple off-ramps: a records check, a supervisor call, a pause. Any of them would have ended the interaction quietly. Nothing compelled further action. Nothing demanded escalation. But moral certainty does not prevent procedural failure. In fact, it often conceals it. The very qualities that made her uncontroversial also made her vulnerable to a system that prioritizes assertion over confirmation. When authority is exercised against someone who does not resist, errors can persist longer than they should. The groundwork had been laid, not for conflict, but for imbalance. And once imbalance enters a legal interaction, correction becomes increasingly difficult the longer authority insists on being right. The day had not been marked by urgency. There were no warnings, no unresolved disputes, no circumstances that would have drawn attention to the residents. The doctor arrived as she had countless times before, moving through familiar routines, shaped by habit rather than concern. The property was quiet. The surroundings were unchanged. Nothing suggested that the ordinary sequence of events was about to be interrupted. The residence itself presented no ambiguity. The structure, the entryway, the markings of ownership all aligned with a privately occupied home. Utilities were active, personal effects were visible. There were no indicators of vacancy or unauthorized use. From an observational standpoint, the scene offered stability, not uncertainty. When the officer appeared, the interaction initially resembled a routine inquiry. The tone was formal. The distance between them remained measured. There was still space for clarification, still time for verification. At that moment, the encounter existed within the boundaries of normal administrative contact, precisely the kind resolved, without documentation. The doctor responded as expected. She acknowledged the presence of law enforcement. She answered questions directly. She did not rush to justify herself. Her assumption was that the matter would conclude once basic information was exchanged. That assumption was reasonable. In most cases, it would have been correct. This was the final moment in which resolution required nothing more than confirmation, a database query, a brief call, a pause long enough for records to align with reality. The legal system allows for these moments specifically to prevent escalation where none is warranted. Instead, certainty replaced inquiry. The officer's posture shifted subtly, not toward aggression, but toward finality. The conversation ceased to be exploratory. Statements were no longer provisional. What should have remained a question hardened into an assertion that did not account for contradiction. From the outside, the transition was nearly invisible. There was no dramatic exchange, no visible provocation. The ordinary simply narrowed. Options closed without announcement. The encounter crossed from routine contact into procedural commitment. This was the last point at which the outcome could have changed quietly. After this moment, every action would be recorded. Every decision would carry institutional weight, and every assumption would become increasingly expensive to undo. Normalcy had not vanished. It had been replaced. Once the assertion was made, the interaction shifted into a procedural channel that allowed little flexibility. The officer no longer spoke in terms of verification. The language changed to compliance. Instructions were delivered as conclusions rather than steps, framed as obligations already triggered by an assumed violation. The doctor repeated, calmly, that the residence was hers. She offered to provide identification. She referenced ownership, not defensively, but as clarification. Each attempt was met with a narrowing response. The officer did not dispute the claim directly. Instead, it was bypassed. Procedure replaced context. The explanation given was administrative. The phrasing relied on process rather than facts. Trespassing was treated as established, not alleged. The burden shifted instantly, without notice, from the state to the individual. It was no longer a question of whether authority applied, but how quickly compliance would occur. The tone remained controlled. That control masked the escalation. There were no threats issued explicitly, no physical force employed, yet the structure of the exchange left no room for correction. When the doctor hesitated, the hesitation itself was framed as resistance. When she asked for confirmation, the request was treated as delay. This is how power often expands without raising alarms. Not through intensity, but through insistence. The officer referenced policy without citation. Standard language was used to justify direction. The words sounded procedural, but they carried consequences. At this stage, the encounter could still have paused. A supervisor could have been contacted. Records could have been reviewed. None of those options were pursued. Instead, the officer reiterated authority. The repetition was decisive. The assertion of trespass was no longer provisional. It was operational. The doctor's responses remained measured. She did not invoke legal doctrine. She did not challenge jurisdiction. She stated facts, ownership, residence, identity. Each statement should have slowed the interaction. Instead, they accelerated it by introducing contradiction that authority was unwilling to reconcile. From a procedural standpoint, the interaction began accumulating weight. Statements were made that would later require justification. Decisions were taken that would have to be defended in writing. Each step forward reduced the viability of retreat. This is the critical failure point. Not the initial misunderstanding, but the refusal to reassess once conflicting information was presented. The system allows for error. It does not tolerate persistence in error without consequence. The officer's posture remained formal. Commands were phrased as expectations. Compliance was assumed to be imminent. The scene remained outwardly calm, which would later complicate its evaluation. There was no spectacle to obscure the record. Everything was clear. Everything was audible. That clarity would matter. The escalation did not require force because authority had already been asserted as sufficient. The legal justification was implied rather than articulated. That implication would later be examined closely, line by line, against statutory limits that do not bend to confidence. By this point, the encounter had crossed a threshold. It was no longer about resolving a situation. It was about enforcing a conclusion that had already been drawn. Every subsequent instruction flowed from that conclusion. Every refusal to pause increased exposure, and every minute extended the record that would eventually be reviewed outside the presence of the badge. The interaction continued, orderly on the surface, irreversible beneath it. At this stage, the encounter passed several legal thresholds without acknowledgement. None were announced. None required escalation to be recognized. They existed quietly, embedded in procedure, waiting to be crossed. The first boundary concerned authority to detain. Trespassing, under state law, requires a foundational element, lack of lawful presence. Ownership or lawful occupancy negates that element entirely. Once the doctor stated that the residence was hers, the legal burden shifted back to the officer to verify before proceeding further. Verification was not optional. It was the mechanism that preserved legality. That verification never occurred. The second boundary involved reasonable suspicion. Even absent ownership, enforcement requires articulable facts supporting continued detention. A claim of residence is not obstruction, it is information. Treating it as resistance converts clarification into cause, a transformation the law does not permit. This distinction is subtle but critical. Citizens are not required to resolve police uncertainty at their own expense. The law places that obligation on the state. When an officer continues action despite unresolved factual conflict, the interaction enters a zone of constitutional vulnerability. The third checkpoint involved procedural escalation. Once instructions were framed as compulsory, the encounter assumed the structure of enforcement rather than inquiry. That shift triggers heightened standards. Commands must be justified. Authority must be grounded. Silence or hesitation by the individual does not supply that grounding. At no point did the officer articulate a basis beyond assertion. Policy language was referenced, but not connected to observable facts. That omission would later matter more than tone, posture, or intent. Courts do not evaluate confidence. They evaluate justification. Another common misconception surfaced here, that compliance cures illegality. It does not. An unlawful detention does not become lawful because the subject remains calm or cooperative. In fact, compliance often preserves evidence of overreach by allowing the interaction to proceed uninterrupted. The doctor's behavior followed that pattern. She did not escalate, she did not flee, she did not obstruct. Each of those facts narrowed the legal justification for continued enforcement rather than expanding it. There was also a missed opportunity for supervisory review. Department policy allows officers to pause when ownership disputes arise at private residences. A call to confirm records would have resolved the matter conclusively. The absence of that call transformed a correctable misunderstanding into a documented failure. These checkpoints are rarely dramatic in real time. They do not announce themselves. They are crossed quietly, through omission rather than action. That is why they are often overlooked by those exercising authority. But they are not overlooked later. When the record is reconstructed, each checkpoint becomes a marker. Each unanswered claim becomes a question, and each procedural shortcut becomes an exposure point. By the end of this phase of the interaction, legality was no longer assumed. It had to be defended. And the available justifications were already thinning. The law had not intervened yet. It had simply begun keeping score. The turning point did not arrive through confrontation. It arrived through preservation. At some point after the encounter, the narrative stopped belonging to the participants and began belonging to the record. Video footage, timestamps, dispatch logs, and written reports entered alignment. What had felt linear in the moment became segmented, measurable, and replayable. The most consequential element was not what was said, but what could be reviewed. Camera footage captured the tone accurately, calm, controlled, devoid of visible chaos. That calm would later undermine claims of urgency. There were no gestures suggesting threat, no movements justifying heightened response. The absence of instability made the procedural choices stand out in sharp relief. Audio captured the exchange with clarity. The doctor's statements of ownership were audible. Her offers to provide identification were preserved. The officer's repetition of trespassing was equally clear. There was no ambiguity about what information had been presented, or when. Dispatch records added context. No active call for service. No corroborating reports. No prior alerts tied to the address. The enforcement action existed in isolation, unsupported by external inputs that might have justified speed or certainty. Written reports followed. Language that had sounded procedural in real time was now fixed in text. Assertions that could not be substantiated remained unqualified. The absence of verification steps became visible not through accusation, but through omission. This is where the balance shifted. Once evidence enters review, authority loses its insulation. The badge no longer interprets events. The record does. Each frame narrows discretion. Each timestamp limits explanation. Confidence becomes irrelevant. Internal reviewers did not need to speculate about intent. They examined sequence, statement followed by statement, claim unanswered, verification absent. The structure told the story without commentary. The doctor's conduct, when isolated in the record, appeared consistent throughout, cooperative, non-confrontational, legally coherent. That consistency mattered. It removed alternative narratives. There was no escalation to reinterpret. What remained was process. Evidence does not accuse, it constrains. It eliminates versions of events that cannot coexist with what is preserved. By the time the record was complete, the question was no longer whether authority had been exercised improperly, but how the failure had been allowed to persist uninterrupted. At this point, outcomes became procedural rather than discretionary. Reviews led to referrals. Referrals triggered external examination. The matter exited the department's internal orbit. The officer's role diminished. The system took over. From here forward, the resolution would not depend on testimony. It would depend on playback. And playback does not negotiate. The moment authority lost control was not when the encounter ended. It was when the evidence stopped belonging to it. As the review widened, the focus shifted away from the individual encounter and toward the structure that had allowed it to proceed unchecked. What initially appeared to be a single failure of judgment began to resemble a familiar pattern, one sustained not by intent, but by institutional tolerance. Internal records revealed that the officer's actions were not anomalous. Prior encounters showed a consistent reliance on assertion over verification, particularly in low-threat situations where procedural shortcuts were unlikely to be challenged in real time. None of those incidents had resulted in formal discipline. Each had been resolved administratively, quietly closed without escalation. That silence mattered. Supervisory oversight had functioned reactively rather than preventively. Reports were reviewed for completeness, not accuracy. As long as required fields were filled and language remained procedural, contradictions were rarely interrogated. Ownership disputes at private residences were treated as routine inconveniences rather than constitutional fault lines. Training materials emphasized control and compliance. Verification protocols existed, but they were framed as best practices rather than mandatory safeguards. In practice, that distinction blurred accountability. Officers learned that certainty was rewarded with efficiency, while hesitation carried the risk of scrutiny. The department's complaint history reinforced the message. Civilian complaints alleging improper detention were routinely classified as unfounded when no physical force was used. Calm encounters did not trigger alarms. Absence of confrontation was mistaken for absence of violation. This structure produced predictable outcomes. Authority could be exercised incorrectly without immediate consequence, as long as it remained composed. Errors that escalated emotionally were corrected. Errors that escalated procedurally were archived. The doctor's case disrupted that equilibrium because it produced a record that could not be minimized. The evidence was complete. The legal exposure was measurable. And the complainant possessed the credibility and resources to pursue review beyond internal channels. Once external investigators examined the department's practices, the narrative broadened. Similar encounters surfaced, not identical in detail, but aligned in structure. Assertions made without verification. Detentions justified retroactively. Supervisory review that deferred to officer discretion without examining factual foundations. The system's vulnerability was not corruption. It was normalization. No single decision had been flagged as unacceptable. Instead, incremental tolerance accumulated. Each unchallenged shortcut made the next one easier. Over time, the department became efficient at processing encounters that should have stopped earlier. The investigation did not accuse individuals of malice. It documented workflows. It traced how discretion traveled through layers of review without encountering resistance. It showed how policy language that permitted flexibility had been interpreted as permission to bypass safeguards. This is how institutional failure presents itself in court, not as conspiracy, but as consistency. When patterns reach that stage, remediation becomes unavoidable. The issue is no longer whether a single officer erred, but whether the system created conditions in which error was likely to recur. That determination carries consequences beyond discipline. It implicates training standards, supervisory practices, and municipal liability. It transforms a civil claim into a structural reckoning. By the time the department acknowledged the scope of the problem, responsibility had already diffused upward. What could have been resolved quietly now demanded formal response. The case no longer belonged to the officer. It belonged to the system that had enabled certainty without confirmation. Once the matter entered formal litigation, discretion gave way to obligation. Depositions were scheduled. Records were subpoenaed. Internal reviews that had once relied on summaries were replaced by sworn testimony and documentary comparison. The encounter was no longer evaluated for policy compliance alone, but for constitutional consequence. The civil claim advanced on narrow grounds: unlawful detention, violation of property rights, failure to verify lawful presence. Each allegation corresponded to a moment already preserved in the record. The defense did not dispute that the residence belonged to the doctor. That fact had become incontrovertible. The argument shifted instead to reasonableness, to whether the officer's belief could be justified at the time. That argument did not survive scrutiny. The footage demonstrated that verification was available and declined. Dispatch logs showed no urgency. Department policy, when read in full, did not authorize enforcement absent confirmation in ownership disputes. What remained was discretion exercised beyond its limits. Qualified immunity was raised, as expected. It was tested against clearly established law governing trespass and detention at private residences. The court's analysis did not hinge on intent or demeanor. It focused on sequence. When lawful presence was asserted, authority was required to pause. It did not. The immunity defense failed. Settlement discussions followed. The municipality evaluated risk not only from this case, but from the precedent it would set if adjudicated fully. The exposure extended beyond damages. An adverse ruling would formalize standards the department had treated as optional. The city moved to resolve the matter under terms that acknowledged liability without protracted trial. The final amount reflected that calculus: just over $2 million, paid not as a penalty, but as a judgment recognizing constitutional injury. The figure was sufficient to demand public accounting. Budget adjustments followed. Insurance carriers revised assessments. The incident entered municipal reporting. Administrative consequences moved in parallel. The officer was separated from service. The decision cited loss of confidence in violation of departmental standards. The badge was surrendered. Certification was withdrawn. Appeals were filed and denied. The separation became final. No criminal charges were pursued. None were required to establish consequence. Civil accountability had done its work. The outcome was documented, binding, and irreversible. For the department, the resolution triggered mandatory review. Training modules were revised. Verification protocols were reclassified from discretionary to required. Supervisory audits were expanded. These measures were not framed as reform, but as compliance. The law had moved deliberately. It had not raised its voice. It had simply applied pressure until the structure yielded. This is how legal consequence manifests when authority exceeds its boundaries. Not through spectacle, but through process. Not through outrage, but through findings that cannot be appealed away. The encounter ended quietly. Its consequences did not. After the judgment was finalized and the administrative actions concluded, the case settled into the public record with a permanence that could not be revised. It was cited not for its drama, but for its clarity. The facts were simple. The failure was procedural. The outcome followed established law. Within the department, the incident became instructional. Training materials were updated to reflect mandatory verification requirements in ownership disputes at private residences. Language that had once allowed discretion was narrowed. Supervisors were directed to document not only actions taken, but alternatives considered and rejected. The goal was not deterrence through punishment, but prevention through structure. Municipal risk assessments changed as well. Legal counsel advised that similar encounters now carried predictable exposure. Insurance carriers adjusted premiums accordingly. The cost of assumption had been quantified, and it was no longer abstract. Cities understand liability when it appears on balance sheets. Beyond the institution, the case circulated among civil rights practitioners as a reference point. It illustrated how calm encounters can still produce constitutional injury. It demonstrated that cooperation does not waive protection, and it reinforced that lawful authority requires continuous justification, not initial confidence. There were no protests tied to the outcome, no calls for retribution. The resolution did not rely on public outrage to sustain its legitimacy. It relied on documentation, adjudication, and enforcement mechanisms already in place. That restraint mattered. It preserved the authority of the result. The case did not stand as an indictment of policing, but as a delineation of its limits. Those limits were neither novel nor extreme. They had always existed. The verdict merely reaffirmed them. For the doctor, the matter concluded without public spectacle. The judgment restored standing rather than attention. For the officer, the consequences were professional, not personal. The separation from service was final, but it followed process. What remained was precedent. Quiet, binding, and instructive. The system did not collapse. It corrected itself.